So let's talk a little bit more about being a landlord. I see this all the time. I have people that come to my office, and I'm talking about people who have millions and millions and millions of dollars. And you think they'd be really sophisticated when it comes to investing and really sophisticated when it comes to their asset protection. But I'll see this. So I'll see a piece of property or several pieces of rental property, and they'll exist literally in their living revocable trust. We have this 4-unit here, and this 3-unit there, and this 2-unit here, and they're all proud. We have it properly deeded into our living revocable trust. I look at that, and it makes my heart skip a beat, all right? I say, let me ask you a question. Who is the landlord at every single one of those properties? And they'll say, it's my trust. But trust provides no asset protection, plus they have all their other assets in their trust anyway. So when I get a liability that comes from inside that piece of real estate, it goes to the full extent of their entire net worth. This resolution is their bankruptcy. So I will see, and then I'll see this. I will see sometimes they'll have 1 or 2 pieces of property enclosed in an appropriate LLC, and then another piece of property that sits in their trust. And that property is the one that could take down everything else that they own. So here's a kind of an adage from a lawyer to the group this morning. One, no matter what state you're in, should never be in the business of rental real property as an individual, but should always be in the business in the form of an entity. Always. Universally, the risk is extremely way too high. But then there's another side to it. The other side is even more interesting. So we now know that if I have a property that has a $600,000 net equity, and that is the appropriate landlord, and there's a liability at that property, it should be limited to $600,000. I think that's wonderful, and I think that's critical and very important. But now let me ask you another question. That's an inside liability. That happened when the carbon monoxide, detector failed. But let's try it the other way around. You have 3 or 4 pieces of property. They sit inside your living revocable trust, and now my wife, the great driver that she is, all right, changes lanes on freeway on Saturday night, all right, and takes out a motorcyclist and turns the motorcyclist into a quadriplegic. It sounds terrible. Actually happened, not to my wife, thank God, but to other cases in my office. So it's a community property state, lovely California, so that I become liable and she becomes liable for that liability. So now the liability did not come from the real estate, did it? No. So now I look down at what does Harry and Tess have that we can take away in order to satisfy the claim. Assuming the insurance company paid X million of dollars, and I still got a judgment that's way in excess of that, they're going to take a look at my stuff. All right. So here's some questions for you. So if those of us that live in California, do you think they could take away our house? What do you think? They can. Some says no, some say yes. Here are the rules, just so you know. Now, if we lived in Texas, could they take away my house? No. We live in Florida, could they take away my house?
That's why O.J. went there.
Absolutely why O.J. went there. Absolutely. Until he was a guest of the state of Nevada, okay? So they can't, Kansas, they can't take, but you gotta live there with Dorothy and Toto. It's just terrible. But, so what happens is here's just so you know, I'll throw it out. If you're a single person occupying a primary residence, $75,000 of equity is exempt from the claims of creditors. Married or 2 people, $100,000. Over 65 or a disabled person living in the house, $175,000. Any more equity than that, we will sell your home, give you a check for the $100,000 and say goodbye. It happens every single day of the week. But let me ask you another question. So we look down at the real property that we have that's sitting in the trust. What about that? Can I take that away? What about all that rental property that I worked so hard with all the 1031s and all the other goodies to do it? Could I take it away? The answer is yes. But if that rental property had been enclosed in a properly constructed LLC in an appropriate jurisdiction with an appropriate operating agreement, I would not be able to take the rental property away from you. That's an outside-in liability. At best, I'd be able to place a lien over the distributions from that LLC, but I couldn't even force you to make a distribution. I get no managerial control. So to a creditor, before, they took all your property away and it's gone. Now, they have a lien on distributions and can't force you to make a distribution. You tell me which way would have been better for you to hold the property.